Welcome. This is going to be a appetizer, a little review of some of the many topics that are going to be discussed at the upcoming Notre Dame 50th Annual Tax and Estate Planning Institute. I can tell you as a speaker and long before as a speaker, as an attendee, it's really an incredible program. Kudos to Professor Jerry Hesch. Lots of interesting topics that you don't hear at any other program anywhere. And one of the themes that I think I could say consistently for many, many, many years at Notre Dame is practical. You learn things that you can take back to your office and take action on, which is great. And it's not the same old, same old. So this is going to be a little introduction or appetizer for the upcoming institute. And we must say this is the 50th institute, quite a milestone. Jerry?
Thank you. My name is Jerry Hesch, and I've been the director of this wonderful program for a dozen or more years. I succeeded to Regis Canfield, and basically am trying to continue the institute in his vision. And Regis told me that our function is to educate the profession to be able to practice at the highest levels of competence. And competence means that we're teaching, and people are going to, your objective is to make sure that you present materials that the people can understand and use to communicate to their clients in an understandable manner. In other words, don't basically talk tax speak, because the clients don't know what a reverse Q-tip is and things like that. One of the things that we have done this year, well, in the past, we've always had concurrent sessions. And the reason we have had concurrent sessions is because you might not be interested in all 26 topics. And so we give you a choice which session you would like to listen to live. But even if you want to listen to both sessions, you have the ability to do that because we have a company that records all the sessions, and you can buy the recordings for the sessions that you miss. We added something differently last year, and we're going to continue it this year. Because it is difficult to take a half a week away from the office and travel, especially to South Bend, which is not a major airport hub, you can now, instead of attending live, for the same registration fee, plus some extra funds to cover the mailing, we will make available to you remotely. You don't have to attend. You can download all the materials from our website a week before the Institute, and immediately after the Institute, our company is going to record all the sessions on a flash drive, or transfer all the recordings on a flash drive, and we will mail you the recording of all the sessions. So if you don't want to attend, you can still participate, and you don't have to be able to block out 2.5 days, because you'll have all the materials and all the recordings separately, and you can listen to them at your own convenience to fit into your schedule. So that's something that we're promoting, and we hope you can take advantage of it if you can't join us in South Bend. So with that, Alan?
Thanks, Jerry. I just want to mention that if you get there Wednesday, you're going to see some really nice afternoon presentations on putting things together for estate planning in ways that you may not have noticed. Thursday is a full day session. If you've never been to Notre Dame, you need to go see the energy of this program and the many choices that you have each day. And what we've done for you today is we've put together some short videos from some of these speakers who you see pictured here. So we can talk about some of the things that you can prepare for and some of the things that you'll receive. In addition, I want to mention that we will have a Thursday evening event at the Studebaker Mansion, which is a very interesting historical building with really nice food, really nice hors d'oeuvres, and the type of Western hospitality that you would expect. A lot of very friendly people attend this presentation. So if you like, I'll start off with Larry Katzenstein's pre-discussion here on charitable gift annuities, and then we can talk about it for a minute.
I'm Larry Katzenstein, and I'm looking forward to seeing you all at the Notre Dame program in South Bend. I'm going to be talking about something that I don't think estate planners think about enough, which is charitable gift annuities. I think a lot of estate planners know everything there is to know about charitable remainder trusts because maybe they're in the Internal Revenue Code and gift annuities are not a creature of the code. Also, there's not much to draft for a CGA. You know, the charities typically provide the document, which is often just one page. But there are so many things that you can do with a gift annuity that you can't do with any other technique. Gift annuities are actually a very old technique, and I'll just show you a picture here on my screen. This is one of the oldest gift annuities. This is the famous painting by John Trumbull of the signing of the Declaration of Independence. And when he was very elderly in the mid-19th century and kind of out of funds, destitute really, he gave all his paintings to Yale University in exchange for an annuity of $1,000 a year. So you can think of that as one of the first documented modern American gift annuities. So that's what I'm going to be talking about. And just some examples of some of the things that we'll talk about. The payments from a gift annuity are usually better from an income tax standpoint than the payments from a charitable remainder trust because you're not subject to the tier system. With every payment, you're getting back part of your investment in the contract. The self-dealing rules don't apply. Gift annuities are issued by public charities. So I can do all sorts of things that I couldn't do otherwise. For example, I can give stock of a closely held corporation to a charity in exchange for a gift annuity. And then I can have family members later buy it back for a fair market value. That's not a self-dealing transaction. You can fund tangible personal property with it to a gift annuity. And that would result in a full fair market value deduction for the value of the remainder. You can't do that with the remainder trust because it's not a related use for the charity. So I think you'll find this program helpful. So many things you can do with the gift annuity you can't otherwise do. You can have deferred annuities. You can have annuities where the deferral period is for a certain period, and then the donor can decide when he wants to start the annuity period running. So there's so many helpful things you can do with them. And like I say, most estate planners don't know much about them. So I look forward to seeing you there, and I think you'll find this presentation useful. Thank you.
Thanks to Larry.
Let me make a comment here. When you transfer an asset or cash to a charity, they're giving you a deferred payment obligation, which is nothing more than an annuity that's going to be payable for the rest of your life. You also get a charitable income tax deduction because about 70 to 80% of the value that you contribute is in the form of the annuity, and the remainder portion is an immediate charitable income tax deduction. But here's the key. If I have marketable securities that I intend to sell, and I would like to sell them, but I don't want to report all the gain up front, and I would like to report the gain piecemeal in the future, you basically sell the marketable security to the charity, you realize a gain, and you don't have to report the gain that you realized until the annuity payments are received in the future. So if you're 70 years old, you basically, and you live to age 90, you're going to receive annuity payments for the next 20 years, and each annuity payment that you receive in the future is going to, a portion of it is going to be the gain you realized when you sold the marketable security to the charity. It's a very creative way to defer the gain on the sale of any asset, but most importantly, marketable securities, which is the easiest thing to do. Okay.
Pri- Gift
Here-
annuities are a very creative concept. Larry's right. I don't think most practitioners are really familiar with them. And a lot of people that practice don't only work in the $100 million transaction area. I haven't thought about gift annuities for large dollar transactions, but for a lot of moderate wealth clients, and that can be a fairly significant level of wealth because the exemptions are so high, gift annuities provide a very creative way to plan not only for tax deductions, but to meet personal goals of the clients. So if you have a client that is struggling with aging issues, putting a part or all of their annual base expenses, living expenses on autopilot, where they buy an annuity and it guarantees a certain payment to their checking account, and you have all their billing on auto pay, is a great way to protect an aging client that may not have a large family base. I've seen interesting things done with tangible property, as Larry mentioned, and we'll all occasionally run into clients that have a collectible item that's quite valuable, and this could be the perfect solution. So very interesting topic, and I think will add to the quiver that we all carry of planning ideas.
Absolutely. Okay, now we're going to hear from Robert Kirkland on the Secure Act.
Well, hello, ladies and gentlemen. My name is Robert Kirkland. I'm in Kansas City, Missouri, and it's my pleasure to return to the Notre Dame Institute on Estate Planning, and I have the privilege of talking about the Secure Act 2.0. I will attack it from a very practical standpoint, i.e., what do we do in response to these recent laws? We have brand new finalized regulations under the Secure Act after waiting for more than 2 years for those to be finalized. We'll definitely talk about those and how they affect your practice. We have proposed regulations, albeit minimal, under Secure Act 2.0. There are some really good things that came out of Secure Act 2.0. There are some other things that need work, and we'll talk about all of that at Notre Dame. I'll also spend particular time on naming trusts as beneficiaries of IRAs, how to do that, when not to do it, if you have to do it, how to do it, that kind of thing. We'll talk about blended marriages with IRAs. They present really interesting issues in estate planning for IRAs and retirement plans, as you already know. There is some Secure Act 2.0 implications in that planning that we'll definitely talk about. We'll spend a little time talking about planning for minors, planning for those who are unfortunately disabled or chronically ill, and talk about applicable multi-beneficiary trusts or AMBITs. I think the final regs made a few positive changes there, not everything that we had suggested. But in any event, I hope you'll be there. Don't fall asleep. This is must-see TV. All of these topics are really, but you know, many of our clients don't have taxable estates, but almost all of them have a significant IRA or retirement vehicle that needs attention. So I believe this is a critical topic, especially now, and I will enjoy visiting with you about that here in about a month. Hope to see you there. Thank you.
That's a very important point because most clients don't need estate tax planning, although we'll have to see what happens with the election and the various proposals, including the one recently floated in Congress. And that advice should be very, very practical from Robert, and something that is really important. And I can say I personally find the constant and in-depth changes to the rules affecting retirement plans is a challenge. So it's always great to hear a practical analysis of it. And the only other point I'd say is I've been mispronouncing his state's name my whole life.
It's a perfect period of time also between the issuance of these regulations and Robert telling us what they say, because all the commentators will finally be done by the time we get there September 26th, and we can go back to our offices and understand what we're going to do for our clients. So great timing on this one, Jerry. So now I've got the amazing Sandra Glazier on what she's going to talk about.
Hello. In today's environment, addressing issues relating to the potential loss of capacity or actual loss of capacity are in the headlines and are issues we as estate planners have to address on a regular basis. Some might say this is like dealing with lions, tigers, and bears. Oh my. And why do we say that? Because there's no one fits all solution to an individual situation when capacity issues are presented. The move today is towards supportive decision making. And even when more restrictive options are utilized, the goal is still to consult with the individual and have them participate to the greatest extent possible. But understanding the options that are available to us as attorneys, whether it be in a proactive estate planning situation or reactive situation because the loss of capacity has occurred and plans either were not put into place or because of dysfunction in the family, additional protective barriers may be required, or because the client does not or individual does not recognize their own limitations and continues to incur debt or place their assets in jeopardy. It's important to understand the options, when they work, when additional protections may be required, and how to properly advise the client and the considerations that they may wish to address. So at Notre Dame this year, my presentation is going to focus on these options and discuss the pros and cons of supportive decision-making agreements, powers of attorney, designations of patient advocates, the use of protective clauses such as Ulysses clauses and other protections within one's trust, as well as court processes that may still be required, and the importance of limiting the extent of those court processes to only those remedies necessary to adequately address the limitations of the individual. There may be times when a fiduciary who can act under a power of attorney because of dysfunction in the family may feel that they don't want to have a situation where the statute of limitations over actions they're taking doesn't begin to run and may be extended for years, decades, before the rights of other individuals to challenge those actions are triggered. And in those instances, it may be the fiduciary who decides that some limited intervention by the court may provide the protections necessary in order to trigger a statute of limitations or get the court's blessing with regard to proposed actions. These are really important issues for any practitioner to understand, because most of us, as well as our clients, are not likely to die not having suffered any diminishment at any period of time during their lifetime in their capacity. It may be a loss of capacity for a very limited period of time because of a medical procedure or situation that may dissipate over time. Or it may be a lack of capacity or ongoing diminishment in capacity that occurs and lasts for the duration of that individual's life, with some fluctuation, improvements, and decline over that period. I hope that you will join us at Notre Dame as we discuss this important area of the law and not rely on the sensational headlines of famous individuals who've had to go through probate proceedings in order to address these issues. Not all processes are bad, nor are all processes good. It is fact dependent, and understanding how those facts and options may interplay will help you be a better planner in addressing your client's needs.
I think that is the single most important topic that any of us in any of the allied estate planning professions should be talking about, because this is something, and Sandy mentioned just some of the headline items without using names, and I'll leave it like that. But what we see in the headlines is not even the tip of the proverbial iceberg. There are too many terrible horror stories of people with diminished capacity having their lives ripped out from under them. And this is really something we all need to focus on more. With the aging population, with the incidence and increase of dementia and other issues as clients age, chronic disease, this is really a crucial topic. And I think that this is the kind of topic that needs real attention at conferences. We tend to focus and get excited about some sexy new estate planning technique that maybe Alan or somebody else has come up with, but this is at the heart of planning for human beings. So kudos to Jerry for even including this, and Sandy's brilliant, so I know it will be a great presentation.
Absolutely. Okay, now the life insurance gurus.
Let me make one comment here. One of the problems with life insurance is it is awesomely complex, and the insurance company illustrations are estimates. That's all. No insurance company illustration ever produces exactly the way they illustrate it. And the problem is we are all basically, our clients are relying on us for advice. And so what Barry and Rebecca are going to do is basically just give you some insights on how to go about dealing with life insurance proposals that your clients receive. It's all really understanding what the insurance policy can accomplish, and whether those objectives in the insurance policy are consistent with the objectives of your client. Because no one policy is good for all. If you want to maximize death benefit, you get one kind of policy. If you're looking for, increasing the rates of return, you get other kinds of policies. And that's really what they're going to do, is help you evaluate policies and also explain your duties to clients when you are giving them, they're relying on you for advice and what you have to do. Thank you.
And these are two real experts who really care about what they're doing.
The life insurance industry is actively fighting against your client's best interest. Don't believe it? Then come to our session about the prudent selection or retention of life insurance according to proven and established fiduciary principles. I'll share with you what's going on behind the scenes of some of these.
Any particular concept or product. So please send us premium finance proposals your client is asking you about, or an in-force illustration that's not working out as expected. In either case, with confidential client information redacted, of course, and we will talk you through what fundamentally misleading theoretically looks like for the benefit of all of you. You'll be getting an email from Jerry with instructions for how to submit the actual life insurance proposals or policies you're grappling with, and we look forward to helping you.
We
We look forward to seeing
you at Notre
at
Dame.
Notre Dame.
That's
The
good.
important, yeah, the importance of this cannot be overstated. Clients will regularly meet, let's say quarterly, sometimes more frequently, with their investment advisor. They'll buy a huge insurance policy, which could be at the core of their planning, and no one ever looks at it ever until it blows up. So this is really a vital thing. I think that it can't be stressed enough what that is. And another point, we're heading into, unless there's some major legislative changes, the crunch of 2026, where lots of clients from now until the end of 25 are going to try to use exemption. And that opens up huge opportunities for using life insurance, disability insurance, long-term care coverage to fill gaps, financial gaps in the planning that results from the use of exemptions. Without understanding what needs to be reviewed with those policies and how to monitor them, which routinely does not happen, our clients are not going to be protected. So I can't think of a more timely topic. And these guys are great. Barry's a brilliant guy.
I always learn something from Barry, no doubt about it. Okay, so that takes us only through Thursday. And we're still on Thursday, and now we're looking at a real tag team.
Hello, this is Paul Hood, and I'm with my frequent co-collaborator, co-conspirator, maybe even sometimes, Ed Morrow. And we're doing a session at this year's Notre Dame conference that is essentially a subset of a 3 90-minute webinar series that Ed and I did on the comprehensive coverage, tax and non-tax issues relating to modifications, terminations, decantings, and commutations. In this session, we have 60 minutes, and we intend to cover primarily the tax, or predominantly the tax consequences. You know, we're going to quickly cover what decanting is, you know, and then we're going to look at, you know, what are the transfer tax consequences? Can things be made effective retroactively, and when are you successful doing that? What risk does the beneficiary take in consenting to a trust modification or decanting? Are any gifts being made? So Ed, what else are we going to cover?
And along with that, I do think we want to touch on some asset protection cases in a similar vein. And I think we want to pay attention to those as well, because, you know, the bankruptcy and creditors don't necessarily have to follow what people agree to amend their trust to do either, right? And then we'll go into affecting GST exemption as well as gift and estate tax. And there, you know, there's been a couple of CCA chief counsel memorandum that have come out in the past few years. One in 2021 regarding Q-tip commutations. Of course, the hottest ticket in the last year has been this CCA that came out at the end of 2023, and it shouldn't be as much of a surprise as it was to the practicing community. It's a little bit of a shot across the bow of how the IRS might be looking anew at the tax effect of trust notifications, I think, Paul. But it's what we want to do is dig in a little bit deeper into how much of that CCA is based on real authority and how much of it is just a scare tactic by the IRS. Believe it or not, there are some prior rulings before the CCA and in even some court cases. We want to talk about those to kind of glean through that CCA. How much should we be worried about that CCA, of course? And there's also some private letter rulings that came out in 2019 that should really scare you on trust commutations. Commutation, of course, is the early termination of a trust. And so we want to work out what are the income tax ramifications of a commutation. And there's a really scary provision in section 1001 of the code, specifically 1001E, in which some cases the current beneficiary, upon termination of the trust, might be deemed to have a taxable sale with a zero basis. And I call it the zero basis apocalypse. And we want to pay attention to that for any trust terminations. Believe it or not, there are some cases when there may be income tax ramifications of substantial modifications as well, and not just non-judicial settlement agreements where everybody agrees. We want to cover the commutations, but also when might decanting be the same as a modification? And there was a little bit of a scare in that CCA where they implied that in many cases decanting might, result in the exact same result income tax wise as a non-judicial settlement agreement might be. We'll talk about triggering of gain when changing from grantor to non-grantor trust and back and vice versa, because that might be a common thing people might want to do in a trust modification, right? So we'll talk about when might a modification that doesn't terminate a trust still trigger gain. There's some private letter rulings out there that you ought to know about, at least to warn your clients about, where even a substantial modification that substantially changes the economic interest of the beneficiaries may be a taxable event under section 1001 of the code. There might be some situations where commutation is still a good thing, but we want to kind of parse out and know what to warn our clients about. And so we want to know when there might be some instances where it might disqualify a quest and some different things like that. And in a nutshell, Paul, I think we just want to make sure that people are aware there's a lot of uncertainty, particularly in the income tax ramifications about this, that we shouldn't be too confident in the answers. But there's some different techniques that we're going to go through in the summary to get around to the same thing with less danger, basically.
Well, I will tell you that anyone who is not familiar with those 2019 private letter rulings, which the IRS plainly says they weren't hiding anything, the commutation is a taxable event, an income taxable event. And right then and there, and we give examples. And in the appendix, I wrote what we call the CYA letter, which is a letter to a client who is a beneficiary of a trust being commuted about what the potential tax consequences are and where the uncertainty is. Because in one of our examples, it was a $20 million gain and the tax was like $4.65 million. Well, clients are going to be upset if they get that bill and they weren't told about it in advance. So Ed, I think hopefully if that doesn't whet your appetite to come hear us in South Bend, I don't know how I can do it any better than that.
Well, we'll look forward to seeing you all there in September.
Yeah. Most of the time people talk about early termination or commutation or modifying what we call private trusts. There's a lot of people who have charitable remainder trusts. And the problem with charitable remainder trusts is the charity doesn't get anything till the client dies. and the client says, I would like to help out my charity today. So why don't we terminate the charitable remainder trust early, and then I'll get the present value of my future income, and the charity will get the rest, which is the present value of the remainder interest. And what Paul and Ed are going to show you is you could end up having a very substantial capital gain to report when all you're doing is dividing the trust assets between yourself and the charity. So they're going to point out some very practical problems that you can avoid if you know about them in advance. Thank you.
This is a real issue what they're talking about. The recent CCA was, as they described, a shot over the bow from the IRS, suggesting to practitioners that we should not assume that any kind of trust modifications, decanting or otherwise, is going to be free of tax problems. And very timely, very important. And again, with the looming deadlines of pre-2026 planning, we may have the desire to change trusts and clean up things and use GST exemption where clients don't have other better uses for it. And all this is going to have to be kept in mind with that planning.
And you know, I think we forgot to mention that Jerry is in touch with every speaker before, during, and after the presentation to make sure that they cover what Jerry thinks is important to cover, and that these are going into white papers. So every one of these presentations includes not just some PowerPoints and a transcript, but a solid white paper that you're going to be able to take back to your office and learn from, both during the program and after. So hats off for all that, Jerry. Next, now we go to Friday. I mean, how much have we learned for Thursday? That's so much to cover. And then Friday, overcoming too much value in GST vulnerable trusts.
It's a very practical problem that occurs when the first spouse dies. They fund their bequests to the bypass trust, that's easy, and then they fund the rest to the marital deduction trust. And the problem with the marital deduction trust is all it does is postpone the estate tax to the death of the surviving spouse. And so what happens is the surviving spouse in the Q-tip trust gets a substantial bequest, and all those assets are in the trust. And guess what? They appreciate in value. And if the surviving spouse lives 10, 15 years, the assets can more than double in value. So the problem is, what Chris is going to do is, you have a GST, you have a trust that's exposed to generation skipping, you're going to end up increasing the generation skipping. So Chris is going to tell you all the problems and then try to come up with some solutions. Okay.
I will be speaking on Friday, September 27th at 8 a.m. My title is Moving Time, Overcoming Too Much into GST Vulnerable Trusts. The conversation that I plan to share relates to a couple of big themes and then a couple of smaller nuanced approaches for planners. Importantly, and perhaps differentially, the issues I will address do not depend on the extension or the expiration of the Tax Cuts and Jobs Act in 2026. I'm sure the audience is very familiar with and heard enough about slats and other reciprocal trust doctrine issues and those types of things to be kind of, tired of those issues. Instead, I'm going to focus on transfer tax issues of generation skipping transfer tax as applied to GST exempt and GST vulnerable trusts. One example I regularly face at the JP Morgan Private Bank is very large Q-tip marital trusts. The risk of the deemed gift under Code Section 2519, which causes a deemed gift if a portion of the spouse's qualified income interest is ever gifted away. Even $1 of a gift will cause the entire trust to be considered a gift of the entire trust that the beneficiary is making. Of course, there's also GRAT remainder trust, which of course cannot be GST exempt because of the estate tax inclusion period during the term of the GRAT. The Q-tip marital trust is particularly intriguing because of the abundance of wealth that runs through revocable trusts and the inevitability of funding large Q-tip trusts to defer the estate tax until the second of the spouses passes away. Because of the likely asset size and the limited GST exclusion, these trusts are normally not GST exempt, so they're GST vulnerable. But this could lead to some great planning opportunities with these trusts. I'll be discussing that at the Institute, of course, in more depth. But of course, the May decision, U.S. Supreme Court decision in Annenberg, tax court decision in Annenberg, was very helpful in telling planners additional ways to plan with these marital Q-tip trusts. I'm going to focus also on the income tax ownership of trusts under Code Section 678. The use of an entirely owned trust to transact with the owned trust is the key to movement of appreciating assets between and arranging assets in the proper trust. I think the flexibility down the road that could be inserted into the trust to do some of this planning is somewhat in jeopardy because of the CCM 2023 52 2018 that was given to us last year, in which the Assistant Chief Counsel gave us indicated that a change of a trust with beneficiary consent could subject that change to a deemed gift treatment in favor of the grantor or in favor of the beneficiary, depending on the issue that is subject to the consent. I think that leads to a great risk to establish GST trusts where the beneficiaries could be the most recent transferor for generation skipping transfer tax and thus blow up some already great planning. So there's risks to these operations: fiduciary risk, IRS risk, assignment of income. I'm going to discuss all these risks as part of my presentation in September. I'm not going to go over specifically the nuances of the complex GST exempt system. Steve Bono, who's going to be speaking later that day on September 27th, is going to go into those nuances, and I look forward to his presentation. I believe that in addition to the CCM I already mentioned, there's several other cases that bear on planners and what we need to be mindful of and the opportunities we can capture. The U.S. Supreme Court's decision in Loper Bright Enterprises versus Raimondo invalidating the Chevron doctrine and could lead to greater arguments against some of the really draconian IRS rulings and interpretations. Similarly, the Rev Rule 2024-14 dealing with the IRS's focus on partnership basis shifting among related parties could change the way we think about some of the operations that we're engaging in. I think it's a tremendous time period to be in the transfer tax planning environment, and my hour-long talk on September 27th won't focus hardly at all on the Tax Cuts and Jobs Act. I hope that the value that I can provide in this presentation for all planners will lead to additional considerations for every trust, whether they're revocable or irrevocable. So I look forward to seeing you on September 27th.
Wow.
It's a great topic. It'll be interesting to hear his comments on Loper and some of the regulations, regulatory guidance that he feel may be vulnerable because of that. That's something that the profession is still grappling with, and I haven't seen much on it yet.
Yeah, and there's so many large Q-tips that need to be handled. So that's just a lot of really important stuff. Jerry, any intro to the Jerry Buyer?
No, it's Jerry Buyer. What else should I say?
Hello, everyone. My name is Jerry Buyer, and I'm excited to be with you to discuss artificial intelligence in the trust and estate practice. You see, artificial intelligence is getting a tremendous amount of press in both legal and non-legal circles. The goal of my presentation is to give you the background you need to gain the basic competency you need, because you see, ABA Formal Ethics Opinion 512 states that lawyers need not become generative artificial intelligence experts, but rather lawyers must have a reasonable understanding of the capabilities and limitations of the specific AI technology that the lawyer might use. And that's going to be our goal, to give you that reasonable understanding. And to do that, here's what we will cover. We'll talk about what we mean by artificial intelligence and basically how it functions. And we'll look at how you can use AI in your trusts and estate practice. For example, you could use it to help automate drafting way better than regular document assembly programs. You can use it to do document analysis, predictive analysis and decision support, automation of estate and trust administration, client onboarding, and others. So now that you'll see that AI can become a very valuable part of your practice, we need to learn how to use AI competently. And one of the big things to be aware of is that artificial intelligence hallucinates. In other words, it does not really think, it is just putting words together according to sophisticated algorithms. So you have to be aware that you must verify everything that AI produces. And we'll talk about how you can design prompts, in other words, the questions you ask the AI to lessen hallucination issues. We will then spend a significant amount of time looking at various ethics concerns that arises with the use of AI. One being confidentiality, because the AI remembers anything you tell it. So if you tell it specifics about a particular client, it now knows that and can use that information and tell other people who are using that AI that information. So we're going to focus on confidentiality. There are other ethics concerns as well. For example, do your clients need to know you use AI? And even more, do you actually need express client consent to use artificial intelligence? And then whether you need to tell the court that you use artificial intelligence to prepare pleadings or briefs or other filings. There's a growing number of courts that require you to disclose that and to verify that you've checked everything. Then we'll talk about the requirement that you train and supervise your staff, because everybody from the lowest level secretary or paralegal to the senior partner needs to comply with and know about all of these ethical and competency concerns regarding AI. We'll talk about what you can do to improve artificial intelligence. We'll talk about billing issues. Basically, you can't bill for the time you saved by using AI, but you can bill for the time that you spend using the AI. And we'll talk a little about advertising. Can you say something like, my AI is better than your AI? So we're going to look at this host of ethics concerns. We're also going to look at a variety of other artificial intelligence concerns. One big one is artificial intelligences now are available to lay people to do estate planning. There's dozens of consumer EP, estate planning AIs out there that don't need lawyers. How do you position yourself against those? We're also going to look at some other AI skills that you need to be aware of, such as decoding keyboard clicking. In other words, if you're at a coffee shop and someone's next to you with their phone open recording and they just are recording your clicky clacky on the keyboard, AIs can decode that back into what you typed. And there's also voice cloning. So if someone calls you, your client calls you and talks to you, maybe that's not the client actually talking, but an AI, and someone is just typing in what they want the client to allegedly say, like, change my will, cut out this child, and put that child in. So we're going to be doing all of that during our presentation, and then we'll wrap up with some bottom line recommendations to hopefully make sure you can now realize and gain the competency you need to use AI in your practice.
What a
Very-
great speaker. What a great speaker he is.
It's a very hot topic. It's very important. And nobody should underestimate how important that's going to be for our future. the AI products that are being made available on estate planning to the financial services industry are going to eat our lunch, because financial planners who are billing an asset management fee are now going to be offering AI generated estate planning services and may not even charge for it. What's going to happen to us? But understanding the current limitations, at least in AI, will help us understand how to deal with that. Very, very important topic.
Yeah, and certainly a wonderful speaker. I'm looking forward to that presentation.
Hey everyone, this is Steve Bono, Senior Tax Counsel with the Northern Trust Company in Chicago.
Jerry, do you want to introduce?
Our next speaker is, he also teaches the generation skipping course in the graduate program in estate planning at the University of Miami. And the theme of his course is all of the mistakes that people can make when they're doing generation skipping. And it's a very practical speech, because he's going to basically just point out a litany of little details that you have to consider. Okay.
Hey everyone, this is Steve Bono, Senior Tax Counsel with the Northern Trust Company in Chicago, Illinois. Today I'm going to give you a preview of my presentation at the 50th Annual Notre Dame Tax and Estate Planning Institute. So the title of my topic is Of Swifties and Skippies, a modern take on the GST tax, straight from the not-so-tortured planners department. So let me talk about the title. The title is derived, or it's a nod to Taylor Swift's most recent album, The Tortured Poets Department. So I'm sure you're probably all thinking right now, is this guy really going to talk about the GST tax and Taylor Swift at once? And the answer is, yes, I am. Let me kind of tell you a little bit about how it all started. Are you ready for it? So let's go back to the spring of 2023. And that's when the Eras Tour started in the United States. That's also when I started to think about putting together another article with respect to the GST tax. And what I decided to do, based on Taylor Swift being in the limelight and being someone who's always loved music and pop culture, what I decided to do was to take various GST tax issues and set them to a playlist of Taylor Swift songs and lyrics. And essentially, each song title serves as the soundtrack for that particular topic at issue. And so I started to do some research, started to learn a little bit more about Taylor Swift and her music. I was a pretty casual fan. I did not consider myself to be a Swiftie. For those of you who are familiar with Taylor Swift, you know that the Swifties are the most passionate and loyal members of her fan base. But I started to kind of draw some connections between Taylor Swift and her music and the generation skipping transfer tax. And so now we're at the present time. We know of the enormous financial impact that the Eras Tour has had on local economies as it stops on various cities around the globe. And we know about the enormous effect that Taylor Swift has had in the academic world. There are colleges and universities, as well as law schools, that are teaching classes that involve Taylor Swift. There are classes that bring in subject matters from intellectual property to literature, all involving Taylor Swift. And so that brings us to our title for my presentation. That is a modern take on the GST tax, straight from the not-so-tortured planners department. During my presentation, I am going to kind of serve as the fictional chair of the tortured planners department. You could say it's at Taylor Swift University School of Law. And what I do is I study tortured planners. They're really the subject of this academic department. And so I'm going to study tortured planners in the context of Chapter 13, the GST tax. What do tortured planners do incorrectly when it comes to Chapter 13? And then I'm taking the viewpoint from the not-so-tortured planners department, given my experience with Chapter 13 in my job here at Northern Trust. I spent a lot of time on Chapter 13 based on the number of trusts that we administer that are subject to the GST tax. And so I'm going to give you some tips to follow. I'm going to point out some traps to avoid when it comes to the GST tax. Again, all from my perspective, the not so tortured planner. And so this is what we're going to talk about. We're going to talk about the basic concepts. I'm not going to assume that you have any level of understanding when it comes to the GST tax. We'll go through shared provisions of within Chapter 13 that have some overlap to Chapters 11 and 12, and really point out the nuances or the differences between how those provisions are applied within Chapter 13 and how they are written and applied within Chapters 11 and 12. We're going to talk about some current developments. We'll talk about the Green Book, as well as new regulations that have been released by Treasury on May 6, 2024, with respect to 2642 G1. I'll focus on exemption because that's what the Green Book has highlighted for several years, really kind of limiting its duration. But I really want to walk through how you allocate GST exemption. You can allocate manually, or you can rely on the automatic allocation rules. What happens if you do something wrong with respect to allocating exemption? If you make a mistake in allocating or not making an election with respect to a trust that should be treated as a GST trust, or opting out of those rules? Well, that's where the final regulations under 2642 G1 come into play. And I'll explain how you can actually go back, use these regulations to make an election or make an allocation, and have that allocation or election treated as if it were made timely. If that process is too cost prohibitive for your clients, then I'm going to talk about late allocations of GST exemption. Of course, everyone is talking about making full use of the bonus GST exemption and basic exclusion amount, which is set to go away. Under current law, we're only going to see these amounts until 1/1 of 2026, and then we're going to revert back to the levels pre-2018. Your clients can use their GST exemption that they have available now to make a late allocation to produce an inclusion ratio of 0 for a trust that is currently non-exempt. What happens if even after that late allocation, you do not have an inclusion ratio of 0? Well, then I'll talk about qualified severances and how you can basically ditch that inclusion ratio, get rid of it, and then create two brand new trusts. One have an inclusion ratio of 0 and the other have an inclusion ratio of 1. So those are the things that I'm going to talk about, all in the context of Taylor Swift. And I hope to see you next month at the 50th Annual Notre Dame Tax and Estate Planning Institute.
Bravo, that was excellent.
I think I'm gonna have to bring one of my granddaughters to the program to understand the Taylor Swift references. I think what he spoke about is going to be really one of the huge overlooked planning opportunities as we head towards 2025 and ultimately the 2026 loss of that bonus GST exemption. A lot of clients that have estate tax planning off radar have exemption. That why lose it if you can use it? So that's a really important topic. And I think that we can open up the planning opportunities for clients well beyond the non-reciprocal slats and yada, yada to use exemption by addressing GST planning. A lot of old sins that have been committed because people didn't pay attention to it for moderate wealth clients, we can clean it up. And that's certainly a big part of what he said he would talk about. Really good stuff. Jerry, I think I'm going to have to come to this.
Okay. Well,
Yeah. Jerry, hats off as always. We've only scratched the surface. We've only looked at 15% of the presentations. You know, let's not forget that Turney Berry and Clary Red are going to start the Thursday off with a comprehensive review, and that they're going to top off the end with another review of what we've learned. So I always look forward to flying into South Bend on Southwest Airlines on Wednesday. I always take a car out back to Chicago Friday night, study my materials on the way there, and then fly back to Tampa on Saturday from Chicago. But who's playing football this year?
Louisville.
So a great opportunity for people to stay for Saturday and see Notre Dame versus Louisville.
Except the room rates triple for Friday and Saturday night.
That's okay because the legal fees and the accounting fees that people are going to earn from being able to attend these presentations more than pay for that tax deductible hotel night.
Oh, one other program that is very important. One of the things that I've always been conscious of is we need to, because we are dealing with individuals who are moderately or significantly wealthy, we basically need to encourage them to give to charity. And besides the charitable gift annuity program, another one of our speakers, who I know very well, is going to talk about creative use of charitable remainder trusts in a way that will encourage people who may not be charitably inclined to give to charity. That speaker happens to be Alan Gassman. And it's going to be basically, how can we encourage people to give to charity by showing them what you actually can give to charity doesn't cost you anything. Instead, what you can give to charity is what you would otherwise have paid in income taxes. And Alan's got a program on that as well. Okay.
Marty, any final words for us? I'm really looking forward to this.
Let's plug my program. I'm talking about trust administration. It sounds as exciting and dynamic as paint drying, but the reality is the Smaldino case, the Levine case, which was a taxpayer victory, really focused on the formalities that they adhered to. The recent Supreme Court case on insurance-funded buyouts. The taxpayers did virtually everything wrong and completely ignored the terms of their agreement. The Firehouse sub case, Sorensen, another issue, a Wandry clause was held not to apply because they didn't pay attention to formalities. So even though it's not nearly as exciting as any of these other topics, it's really important. And again, I think that's consistent with Jerry's theme, which I said in our introduction, focus on practical things that practitioners can really do something with. So sounds like another great institute, Jerry. I can say, as Alan had already said, I learned so much at your programs at Notre Dame. They're just really valuable to attend.
Oh, thank you, Marty. And we hope to remember, if you can't go to South Bend, we still have the ability to download all the materials, save them, and we'll send you the audio recordings for all 26 sessions so you can listen to them at a more convenient time to fit in your schedule.
And think how exciting this is going to make all of you for the holiday season that's upcoming. Just imagine how popular you're going to be at all the holiday parties when you can talk about all these topics.
Oh. Okay, well, with that, let's go.
All right. Thanks a lot, guys. Really appreciate it. I hope if you've enjoyed this video that you'll share it with others and share the Notre Dame experience. It's unparalleled.
Thank you.
Take care, everybody. See you soon.